Welcome back at this year's Bitkom Privacy Conference. We will start this afternoon with Thomas Zerdik from the European Data Protection Supervisor. He will discuss the challenges and opportunities ahead for the EDPS in personal data protection. Mr. Zerdik, very nice to have you, and the floor is yours.
Thank you. Good afternoon, ladies and gentlemen. Greetings from Brussels. First of all, I'd like to thank you for the invitation. It's an honor for me to take part in this conference to talk about, indeed, the EDPS's point of view for current and future challenges in personal data protection. Let me begin by recalling what the EDPS is. Since 2004, the EDPS is the independent supervisory authority responsible for ensuring that the Union institutions, offices, bodies and agencies, what we call the Union institutions EUIs, comply with their data protection obligations. The EDPS is currently supervising 75 EUIs spread out all over the 27 EU member states, including, for example, the European Commission or Europol. The main tasks of the EDPS as supervisory authority are the same as those of the national supervisory authorities, which you know best, ranging from monitoring and advising activities to enforcement and cooperation, as well as providing the secretariat to the European Data Protection Board, the EDPB. So what are the current and future challenges in personal data protection? In essence, I believe they evolve around three key priorities. The first one is nourish, enhancing the effectiveness of data protection for both individuals and public administrations, ensuring stronger safeguards and better outcomes. The second is necessity. We need to address unresolved issues and clarifying ambiguities in the regulatory landscape to ensure a consistent and effective enforcement. And third, navigation. We need to guide our way through the emerging challenges, particularly in the realms of artificial intelligence, to which we are adapting at a rapid pace. So let me come back to number two, enhancing the effectiveness. We are using the celebration of the EDPS's 20th anniversary as an opportunity to take stock of the past and to build on the present, to approach the upcoming challenges in a way that respects individuals' privacy and leaves no one behind. Throughout this year, we are unveiling 20 initiatives, commitments and actions illustrating the EDPS's continuous aspiration to lead as a modern data protection authority. We are promoting new approaches and innovations to our work that we believe will bolster individuals' right to privacy and data protection. And let me give you 4 examples. At the beginning of May, we published our guidance on generative AI. This document provides orientations on various aspects of generative AI and data protection, in particular on issues related to the application of data protection principles when public authorities intend to use such technologies. We are also working on more transparency for data protection complaints and resolutions. We see that the public trust in data protection critically depends on how well infringements on individuals' privacies are managed. And traditionally, the EDPS has processed complaints internally with minimal visibility provided to the controllers, to the EUIs, and the wider public. Our initiative now aims to reform this way and to reform how the EDPS discloses information on complaints and how we handle and resolve them. By sharing more data on the complaints received and their outcomes publicly, we can hopefully demystify how these are handled, highlight our work, and share, obviously, success stories and lessons learned. One of the other missions of the EDPS is to promote a strong data protection culture inside the EU institutions. And to achieve this, one of our key tasks is to carry out audits and inspections, which are crucial to preserve accountability and to preserve high data protection standards. Again, traditionally, only some audit reports and their executive summaries are shared with the public, for example, in annual reports or for internal evaluations. Again, we believe this needs to change, and we strive to be more transparent in our processes and outcomes and to publish more on our audits and inspections, also thereby fulfilling our role as educators in data protection. Then finally, we have the EDPS's 20th anniversary book, where we chronicle how the EDPS came into the existence and how we developed, but it's also a rich resource for you to seek what key experts have to say on specific issues of data protection, compliance, and developments. And obviously, this is a free download from our website, so I can only recommend you to read this. With these initiatives, the EDPS hopes to make data protection work better in the future for individuals, but also for controllers and in particular the EU public administration. Then we come already to the issue of addressing unresolved issues and clarifying ambiguities in the regulatory landscape. After 20 years, there are still important issues to clarify for data protection in practice. I see it every day in my office. And while the Court of Justice in Luxembourg is doing its best to deliver tsunamis of data protection judgments, both the EDPS and the EDPB are engaged in providing further clarity, practical tools, and guidelines. So, for example, as most of you will know, on the 8th of March this year, the EDPS issued a decision against the European Commission following our investigation into the Commission's use of Microsoft 365. And we imposed corrective measures on the Commission. The EDPS did not make this decision lightly, but we found infringements by the Commission of several key provisions of our regulation in the use of Microsoft 365. And that's why we expect the Commission to implement, when necessary with the help of Microsoft, all orders by the EDPS. And since we understand that the Commission will intend to implement those measures, we will assess after the 9th of December this year whether the measures taken comply with the EDPS's orders. And at the same time, the Commission and Microsoft both and individually have brought legal actions against the EDPS decision before the General Court. The EDPS, of course, defends its decision, and these court actions do not suspend our order. I mention these cases because these cases raise important questions for any data protection professional, such as, for example, on the exact obligations of a controller vis-à-vis their processor when it comes to documented instructions, purpose limitation, international transfer mapping, and unauthorized disclosures. Similarly, I'd like to draw your attention to another pending case in the Court of Justice. Our appeal against the General Court's decision in the SRB case will hopefully provide the European Court of Justice with an opportunity to clarify the case law on what is personal data, from whose perspective is personal data personal, and on the notion of pseudonymization, and as well as the principle of accountability and how far it goes. Turning to another point, crucially for the success of the EU data governance framework, which we all are faced with, crucially for that success will be the smooth enforcement between the Commission and other competent authorities in the Member States, but also including data protection authorities such as the EDPS. This is why the EDPB will be working on guidelines on the interplay between EU data protection law, in particular the GDPR, and other EU data laws, including separate guidelines for each of the AI Act, the Digital Service Act, the the Digital Markets Act, and on the interplay between EU data protection and competition law. As regards the still hot topic of transfers, we have published the EDPS Model Administrative Arrangement for transfers from EU eyes to international organizations. And this model hopefully will help EU eyes to comply with the applicable regulations when they need to transfer personal data to international organizations within the remit of their role. This model text covers transfers from an EUI to an international organization as a separate controller. There is no obligation to use this model, but the aim is to facilitate transfers and to help us by accelerating the authorization procedure. We have also come across an important question to be clarified concerning transfers of human resource data under the EU-US data privacy framework. Briefly, as you will mostly know, an entity can self-certify under the DPF for non-HR data and HR data, ensuring an extended protection for the latter. This encompasses, for example, limitations on further processing of the data and competences for supervisory authorities. So what's clear for the moment is that you cannot transfer HR data to an entity which is not certified for HR data under the DPF. But we have seen that when it comes to transfers for entities certified for HR data, it seems that there is a divergent interpretation between the member states and the US Department of Commerce. The US side considers that only HR data shared within an employment context is covered. For example, if the exporter and the importer belong to the same company group. Our view is that if, for example, the European Commission transfers personal data of its staff members to a service provider under the DPF, including cloud services, it should benefit at all times from the extended protection of HR data. So we are working closely with the European Commission to clarify this issue. This question has already been raised within the framework of the EU-US data DPF review. And following this, the Department of Commerce, the FTC, and the EU data protection authorities have already agreed to develop common guidance instruments, also in particular on this question. We have in the EDPS tried to clarify it also something which is essential for any data protection supervisory authority, the right to be heard. From now on, the EDPS will draft a preliminary assessment and communicate it to the controller before adopting a decision concluding on infringement of the regulation or when we exercise our corrective powers. This is an opportunity where we will also involve complainants. They will also get a chance to express their views before a decision from the EDPS which affect them can be taken. This is a streamlining effort on the part of the EDPS to make sure that the right to be heard is granted in our complaints and investigations procedures. Just for your knowledge, to further clarify certain things, the EDPB has just adopted new guidelines on the processing of personal data based on legitimate interests. This is in particular of relevance under the GDPR. And the good news is that these latest guidelines already take into consideration the recent ruling from the European Court of Justice on this matter from the 4th of October. These guidelines will be subject to public consultation until the 20th of November. There are also more guidelines coming up, for example, on the right of access under the Law Enforcement Directive, and many more, all of which you can find in the work program 2024-25 by the EDPB. What are the emerging challenges? I'd like to end my intervention with a few words on the major challenge that I think we all face these days, and we've seen during those 2 days already at this conference, the ever-increasing use of artificial intelligence, and more specifically, the AI Act and its interaction with the data protection framework as we know it. Well, we'll probably all agree that data protection and AI are heavily interlinked, right? The EDPS's message is data protection and privacy will not merge, nor will they disperse into artificial intelligence. We must defend data protection and privacy against the risk to dilute them into the AI hype. In fact, this could only mean dangerously weakening these fundamental rights, and therefore the two must remain separate. However, I'm not naive, and you are certainly not a naive community neither. Of course, artificial intelligence is fueled by data, and much data that some of the operators refuse to recognize as personal because they claim these data have been aggregated or anonymized, or they were publicly available, and therefore data protection doesn't apply. Artificial intelligence and data protection are different, and so are the legislative frameworks related to them, and they all apply in their relevant scope. Artificial intelligence systems should represent an opportunity and not a threat for, in particular, the new generation. So it's important that we all work together to help, in particular, our children to develop a healthy relationship with technology. And this also means setting healthy boundaries around its use. And therefore, compliance with data protection and privacy is the essential prerequisite to put people, us humans, at the center and the head of technology. We must work together to defend this identity of personal data protection to protect, ultimately, humanity. You may know that in addition to its role as supervisory authority for data protection, the EDPS is now the competent authority and market surveillance authority for AI systems put into service and used by EU eyes under the AI Act. And this is in this new role, and not in our role as data protection supervisory authority, we have developed a strategy for the use of AI systems in the EU eyes. And one central pillar of that strategy involves a proposal that every EU public administration should appoint an AI Act correspondent to facilitate compliance with the obligations from the AI Act. This role is not the same as a DPO, cannot replace that function, but it is very clear it's similar, and DPOs in any case must be associated and part of the discussion on AI systems. With these small outlooks for the future, I want to say thank you very much. We are aiming to anticipate these challenges and opportunities, and we are hoping that we will be able to enforce with modern tools and survive essentially in this digital landscape for us all. Thank you for your attention.
Thank you very much, Mr. Serdig, for your overview. As for now, we don't seem to have any questions, so we will head right on to the next point. Thank you once again, and have a good afternoon.
Thank you for having me. Have a good afternoon.
Thank you.